And I wanted to start today by thanking the Connecticut Bar Foundation. A huge shout out to Judge Barry Armada and his colleagues, Natalie Wagner and Sarah Caputo. I also wanted to thank the CBA for sponsoring this event, and especially the Committee on Human Trafficking. That is a committee of lawyers and lots of other non-lawyers. So if you're interested, please let me know. We'd be happy to have you if this is an issue that you're passionate about. And I wanted to thank Quinnipiac Law and specifically the Human Trafficking Prevention Project, that's HTPP, and my third-year student, Cindy Lill, who is the executive chairwoman. She has been an amazing person behind this effort. This is our inaugural event. This is not the first, this is the first event, but it's not the last event. We have an ongoing series sponsored by the CBF, the CBA, and Quinnipiac called Understanding Human Trafficking. So we really hope you will look out for upcoming events. In February, we hope to have a panel already sort of set up on child marriage. And we're going to focus on the US and laws across the country on this issue and to sort of explore how much of this a problem in the United States, how do laws vary across the United States, and we may also take a quick peek at what's going on with child marriage issues abroad. That's considered a big human trafficking issue among advocates. And in April, I really encourage you to look out for a sort of next step to what we're looking at today, decriminalizing human trafficking victims. Experts across the country talk about issues like legalizing prostitution, decriminalizing prostitution, partial decrim, penalizing buyers. And those issues can be very complicated. So we hope to get a group of experts together to sort of talk about these issues and think about where states across the country are going and where Connecticut should go. And so just bringing it back to today's event, thank you so much for coming. Again, I teach in the Quinnipiac Civil Justice Law Clinic. And when we first started taking trafficking cases, we immediately got 3 cases with incredibly compelling stories of human trafficking and survivors who were terrified of the criminal justice system. And we then looked into Connecticut's law and saw that there was an interesting vacatur law, but we're disappointed to find that because they had crimes in their cases other than prostitution, they were not covered by the law. So that, in a sense, is why we're here today. We drafted a bill, and now today we will share with you in the chat right now what we think is just common sense legislation that is based on input from all sides that we are hoping, after hearing some of these issues, we can gain consensus around. And I just wanted to point out before we begin, we had 249 people registered today. And it's sort of bittersweet because we're not going to be able to see all your faces and hear your names and listen to your voice as you ask your questions. And I'm very sorry about that. But I'm thrilled that partly because of Zoom, we could have this incredible panel from Connecticut folks and out-of-state folks, experts from an incredible diversity of perspectives coming here today to share their perspectives on this issue and why they think it's important. And hopefully after today, we can reach a consensus about how we can make our democracy in Connecticut work better for trafficking victims. Finally, again, there are bios and materials on the website, and the link will be in this chat. But I wanted to just say that normally we would do an entirely separate event featuring someone who has survived human trafficking, like Teresa, who's agreed graciously to join us today. And I just wanted to highlight how challenging it has been for us and for her to fit her story into 10 to 15 minutes of discussion today. That said, you've got a bunch of talking heads, and then you have Teresa telling this an amazing story. Sorry to my talking heads, but Teresa's story is incredible. But there's just not enough time today. So we may try to do another event, but I just wanted to apologize in advance for the fact that we're having to sort of fit her in on this panel of experts, even though I think her story really should be front and center. So please, though, check out the materials, because she doesn't have a photo, because she has an amazing article, if you click on her name, that describes a little bit about her story. You can do that now, and has an amazing picture of her, and you will be hearing from her very soon. And with that, I would like to introduce Joette Katz. I am so thrilled that Joette agreed to do this, because she has really been working hard on this issue for many years, and specifically on this legislation for a while now. And in her tenure as DCF commissioner, she has truly put Connecticut on the map as a leader in fighting the human trafficking. She also comes to this panel as a former public defender. And of course, I would be remiss not to mention her time as former Supreme Court Justice in Connecticut. So thank you, an incredible thanks to Joette Katz and all of the panelists for coming together today to discuss, to debate, and hopefully open our minds on this issue. And if I can pass it along to Joette.
Thank you, Sheila, so much. First of all, it's a very impressive panel, and I'm honored to serve as its moderator. So let's begin. Traffickers target and isolate their victims based on vulnerabilities, and then they use force, fraud, and coercion to manipulate and control them. Traffickers beat, rape, and torture their victims as punishment. Some traffickers give their victims drugs to get them addicted. Others brand them as property using tattoos or more vicious markings. Still others threaten to harm or kill them and their family and their friends if they ever disobey or try to leave. Many traffickers do all of these things. This process leads to trauma bonding, a destructive connection between a trafficker and victim created by ongoing cycles of abuse designed to create dependency and obedience. Traffickers often control their victims by compelling them to engage in illegal activity and then threatening to expose them to criminal prosecution. This helps traffickers avoid criminal liability themselves while ensuring the continued vulnerability of their victims. And when victims try to resist or leave their traffickers, they know that their past criminal behavior can always be used against them by the trafficker. A majority of trafficking victim survivors have reported being arrested for crimes other than prostitution or drug-related offenses. These crimes include assault, resisting arrest, forgery, larceny, burglary, loitering, vagrancy, disorderly conduct, and others. And as survivors struggle to rebuild their lives, their criminal records severely limit access to employment, housing, education, and other building blocks of civic life. I want to tell the audience that when I left my position as DCF commissioner, we had identified over 1,000 victims of trafficking, sex trafficking specifically, most of whom began their nightmare, this nightmare that I've just described for you, as adolescents, and frankly, some as young as 9 years of age. Now, Connecticut currently provides for criminal convictions to be vacated. You've got the materials, Sheila identified them. Connecticut General Statute 5495C was first enacted in 2013, but that Vacatur statute really was a beginning, but it was a narrow provision that allowed persons convicted of prostitution to apply to court to get their convictions vacated, but they had to show at the time of the offense that they were a victim of trafficking. 2016, the legislature attempted to broaden the statute, and it is in its current formulation. It broadened it by the inclusion of the language at any time after a judgment of conviction is entered pursuant to 5382, which is prostitution, the defendant can apply to the Superior Court to vacate any judgment of conviction on the basis of his or her participation in the offense was a result of having been a victim of conduct of another person that constitutes trafficking. So it enlarged that piece of it, the connection to when the crime that you're seeking to vacate was actually committed and whether you were still currently being trafficked. But the problem was it linked it to a conviction of prostitution. And as you'll hear, not everybody has a conviction of prostitution. So it tethered it to that particular crime. There's a new bill in front of the legislature, and we're going to be talking about that. It expands the opportunity to get convictions vacated untethered to prostitution. It includes a whole variety of other criminal convictions. There's a debate about whether the exclusion of A and B felonies is appropriate, and we're going to get into that. It requires victim notification. It gives opportunity for prosecutors to weigh in, and it leaves the matter to the discretion of judges. I can tell you that based on my past life, I think that's a very appropriate place for the discretion to rest. We trust our judges to do very difficult things, and certainly this would be among them, and I applaud that. There's a discussion nationally about whether or not there should be a standard of proof, and I expect we're going to touch on that as well. The only other comment I want to make before I introduce our panel is when I talked a second ago about the exclusions of A and B felonies, the point of that is controversial is trafficking itself. Trafficking is an A felony. And one of the topics that I expect our panelists to address is whether or not that should be an exclusion. Because what happens and you'll hear this again from many of them, people who began, largely women, and often, as I indicated earlier, adolescents, get into the life. They are trafficking victims. And then for all the reasons that I identified very early on in my remarks, they become traffickers themselves. And the question is, should they be entitled for trafficking convictions under those circumstances to be able to take advantage of this statute? So with that, let's begin. We have 5 panelists, 2 from Connecticut. You know them: Rich Colangelo, Chief State's Attorney; Jillian Gilchrist, Representative from West Hartford. We have Teresa Leonard, who's already been introduced to you as a victim of trafficking herself and a frequent lecturer. We have Kate Mogilescu, excuse me for butchering your name, Kate, from Brooklyn Law School, and Jenny Rossman, a Florida prosecutor. And with that, let's begin. I'm going to begin with Teresa. Teresa, I'm going to mute myself, and it's all yours.
Hi, everyone. I'm Anne-Marie Boulet, and I'm with the Underground. And I'm going to be working with Teresa today to answer some questions for you so that you might be able to have a good conversation around this proposal. We represent the Underground, Lighting a Way to Freedom. We're a faith-based initiative in the state of Connecticut, and we mainly focus on prevention, awareness, and direct supports to victims and survivors. And so we understand their challenges really well. It's my great honor to introduce Teresa Leonard to you, Teresa Leonard Rosine, actually, who is our survivor mentor leader. She's an advocate for many victims and a mentor to many who have been exploited. She is also one of the co-founders of the Underground, and she's been with us since 2013. We're just going to get started, and thank you all for meeting today and exploring this important topic. So our first question to Teresa is, Teresa, share with us a little bit about your childhood experiences, if you would.
Sure. Can you guys hear me okay?
Mm-hmm.
Okay, good. So I got a little laryngitis today. So if I sound like Joan Rivers, don't hold it against me. So what did my childhood look like? I was born addicted to alcohol and heroin. And my mother, shortly after having me, she left me at the hospital a couple hours, and sorry about that. And nobody heard from her for another 5 years. In that 5 years, after that, she pleaded with the DCYS for reunification. Unfortunately, that did happen, and that is where the trafficking began. And so for the next, from probably 5, 6, maybe, the more I heal, the more I remember. And till I was about 12 years old. Also, my brother, who recently I found out was also trafficked. And I remember him coming back, mom sending him out to work. And when he came back, he would have money. And he'd be like, oh, I stole some car radios. And so deeply ashamed of what he was doing, even though I knew and he knew. So that is, at the end of the day, when my mother was done getting high, I would be put in the closet with a little bag of potato chips, an empty beer can with water in it, and a blanket to sleep. She would close the door and wake me when it was time to go back to work. And to me, that seemed very normal.
When we have Teresa share her story, we do it so that it can inform our work. It's a real privilege to be able to hear your story today, Teresa. I just want to, express to the audience today how important your voice is. And she's describing being essentially exploited at the age of 6 by her mom. We've heard Teresa's story many times over the years, but because she was harmed in this way as a little girl, it did set you on a path, Teresa, in your life, and you just were trying to survive. You experienced a lot of arrests, convictions, and we'd like you to tell us how many convictions you actually had in the state of Connecticut when you were being exploited over your lifetime.
So the last time we had met, Richard had brought a thought process for me. How many times was I arrested with the same person? Many times. I would be the one holding the drugs because he promised that he'd have the girls out working, doing everything he can to get me out on bond. That never once happened. I do remember other girls who he told the same thing to. And we'd be out working hard to get our sister out of jail, and we'd work in, give him the money, and guess what? He never spent it on that woman either. On the last arrest and conviction was being in a stolen car. He was actually driving the car that was stolen. And he was charged as an accessory and got unconditional discharge. Me, on the other hand, I was charged with larceny 3 and a slew of other things. But you know what? Nobody asked. Nobody asked, why are you doing this? And I just thought nobody cared, because that's what it felt like. And when it came to, if you look at my record, there's 17 out of 44 convictions that were failure to peers, because he'd scare me. You're going to go to jail. They're going to keep you forever. And, and I'm not going to be able to get you out. And the girls are going to, fall to pieces. You're leading this team. What am I supposed to do if you go to jail? And very similar to a pattern that happened with my mother. What am I going to do, Teresa, if you don't go out and work? I'm going to be sick. So in my thought process, I'm making a decision to go out and help. That also came at the age of 20, with my sister. She's 5 years older. Putting in her thought process, this is the only way we can take care of ourselves. We are unemployable. This is all we have is our body. So we got to get everything we can from it. So there was a lot of failure to peers, possession of paraphernalia, which is nothing. He would get arrested. They'd shake us down, and I'd have a couple bags on me, and he'd have 40. Yet I was the one that got put in jail. I was the one who he hung out to dry, and still nobody asked. You're homeless. There are holes in your shoes. Why is he driving an $80,000 car and you're starving right now? Nobody asked. And so to answer the question, 44 convictions. Several, when I talked to the bail commissioner or the public defender, and I had a large, there was a time when I had, I took the heat for like 40 bags of crack, and the public defender said, this is the deal. Take this, and otherwise it's going to get really bad for you. So in my mind, everything he told me is now coming true. He told me they're going to charge me. He told me I was going to jail. And now the advocate that's speaking for me is telling me the same thing. So I took those plea bargains. One of them of possession of narcotics with a large amount. Originally, it was in a school zone. It was just a slew of stuff that I took. And she said, you're only going to go for a year. They'll get you in a halfway house. It'll be okay. So I took a plea bargain. And again, my only advocate could not speak for me. And it wasn't their fault. They just didn't know. Nobody was looking. And I was sold to the highest bidder.
Okay, Teresa, thank you for explaining all of that. I mean, 44 convictions that she said. She gave you a few examples. Now we're going to fast forward 14 years from her last arrest. And now she's looking to build a new life. And there's so many obstacles because of these convictions. You know, she wanted to be a recovery coach, possibly get an apartment on her own, you know, with this kind of a record, as all victims experience and survivors who are trying to move on, it's virtually impossible to do that. Senator Blumenthal encouraged Teresa, because they got to know each other through the SESTA bill back in 2018, and some work that Teresa did as an advocate. He encouraged her to go for a pardon. And Teresa, would you just share with us a little bit about that process? The underground stood beside her. The state attorney's office stood beside her. Her church stood beside her. Her good husband was with her. Very difficult process. We'd like you to share about that, Teresa.
It's interesting. I just want to add, I know we have limited time. I just want to add something. You know, when I received a award from some senatorial thing, and on the bottom, it was Senator Blumenthal's signature. And I'm like, you know, the last time I saw that signature, it was on a warrant for my arrest. So, you know, I was able to look at it and able to see that I am in a different place. And I didn't get here on my own. Unfortunately, you know, it was 3 years. In that 3 years, I had given up over and over, and my husband kept plugging along, doing the paperwork, calling. One of the requirements was I was on a probation in 1993, and the process, part of the application was I needed to get a letter from that probation officer to explain what the disposition was. Was I scented? Did I complete? First of all, I really think the original background check would have covered 1993. And in the process of doing that, I went through 5 different people. The guy's not even alive anymore. And I'm lucky that I did have an advocate working with me through the Department of Pardon and Paroles. And she really helped me too, because there were many times I wanted to give up, and I told her that you know, this process is designed to make me give up. It's just dense. It was 100-page document. Each arrest that I had needed to have a level of accuracy of where it happened, what was done, who was I with. I mean, we're talking 44 convictions, and I'm supposed to remember all of those. My application, I sent it. It was sent back several times with insufficient documentation. And it was 100-page long, and it was sent back. Insufficient documentation. I drove all over the state of Connecticut getting documents that were useless, that a simple background check was going to. Here's a good example of, I had put in my application in September of 2018, 18. And was it 16? No, it was 18.
No, it was 18.
So it was definitely 18. So what happened during this, I got a letter back, and the woman who was helping me from the inside, I sent it to her, and she said, "It looks good, Teresa." And a month later, I get an email from her saying, "We're sorry, but your application, that they're not granting you this pardon right now." And they're having another meeting in November, where I could go and actually have visual contact to talk to the board. I was discouraged. 3 years, and then waiting the 30 days was awful. And I was fortunate that when I did go to in the following month, I shared with a friend of mine, Brian Sibley, and I said to him, what did I do? How do I get out of this? I was working a job as a home health aide. I was making $11 an hour, working an hour and 15 minutes away from where I live. And I did it every day because you know what? I grew up on, because of the psych history, I was put on disability in 2019, $700 a month. I kept that because I really believed I was unemployable. And sadly, it was true. Those convictions were preventing me from living in victory. And when you go and you have an application, see how many people said, wow, awesome references. But our policy is.
Teresa, before we leave you, the day that you actually stood before the pardon board, could you just briefly describe some of your experience there? Briefly, please.
So I went to the board. I was the last person, which isn't anybody's fault, but it just gave me a good enough reason to be mad, because I thought that I was going to get denied. So I'm realizing that I am in a shamed base process. I'm a criminal. I am begging for grace so I could go out and have a job where I make more than $11, and which I was qualified to do. So I'm standing next to pedophiles, murderers, asking for a pardon. It was so shame-based to have to sit there and beg, just give me a chance to show you I am not a prostitute. I am not a thief. All I want is to be able to show you. Just give me that. And I was granted that pardon that day. I had a lot of people behind me. And you know what? I probably, honestly, and not just like, people pushed me through, but people told me, don't give up. This is going to happen. Just stay in the process. Don't give up. And then when I got there that day, and I'm not saying that I'm better than them or, but I just felt going up there while they read prostitution, 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 there was judgment. There was judgment from the pedophiles, and it was clear there was judgment from the board. And Brian Sibley was with me, and I believe that would have went a different way if I did not have all of those, which also my faith that God went up there, and even though they judged me, and even though they saw a prostitute, that was not me. That is what I was forced to do. This is me today.
Teresa,
This is what I was denied. I was denied the opportunity to be heard. Sorry, go ahead.
No. Thank you. We could, just so you know, we and all of the listeners could listen to you all day. And I know there will be other opportunities. So I want to thank you so much. And frankly, Teresa and other victims like her are the reasons that we are here today. So thank you so much. And there will be an
Absolutely
opportunity.
welcome. My pleasure.
Terrific. Kate, I'm going to turn this over to you.
Wonderful. Thank you. And good afternoon, everyone. I'm very pleased to be here today because this is a culmination of many discussions over the years, a lot of advocacy that's happened, starting in New York, of which I'm particularly proud, but still critical. And, I see in the attendee list so many colleagues and partners from across the country who have been working to make sure that criminalized survivors of trafficking have avenues for relief. I see our people from Pennsylvania, many of the advocates we've spoken to in Connecticut over the years. I see a DC colleague who's been instrumental in this work as well. So it's just these kinds of conversations and where we are now are an important point at which we can reflect on what we've already accomplished, but what remains to be done. And the legislative effort in Connecticut, I believe, is emblematic of that. So I'd like to frame our discussion it's just in a few ways for today. And for everyone who knows me, attending the 10-minute time restriction is hilarious. So what I will say is when we reach the 10 minutes, you're just going to tell me I'm going to stop talking, even if it's mid-sentence, because otherwise we'll never get anywhere. So who am I? I am Kate Mogilescu. I run a clinic at Brooklyn Law School in New York. It's a defender clinic that focuses on representing victims of domestic violence, human trafficking, sexual exploitation, and other forms of gender-based violence who have been prosecuted, are being prosecuted, or are generally criminalized and marginalized because of that status. I also run a project called the Survivor Reentry Project, which is a national effort to try to get criminal record relief. The term that you're using, or we're hearing here today, vacatur, right, is a form of criminal record relief, a way to clear something from someone's criminal record. Teresa spoke about her efforts seeking a pardon in the state of Connecticut. And the reason why we're having this conversation today is because there wasn't appropriate relief available under the law that Teresa could seek in the courts in the state of Connecticut. And so she had to go to the executive branch and ask for a form of clemency, which, as you heard, was an arduous, difficult process. Our common goal that everyone here, I think, would acknowledge is that we want criminal record relief to be available to survivors of human trafficking. We want it to not be what Teresa just described. And we want it to be consistent with and accessible, but consistent with the experiences of trafficking that we know that Justice Katz, in opening the discussion, described the dynamics that contribute to this. So again, to go back to giving New York credit, sorry, Connecticut folks, it's a tri-state rivalry thing. But New York became the first state to offer any kind of criminal record relief to survivors of trafficking in 2009. So the next decade, really, the next 10 years, we saw the initial passage of laws like this across the state. New York's was the first. Connecticut was not so far behind, but this was what I think of as sort of phase one, right? States were beginning to understand this issue, beginning to look at what they could do legislatively to offer some sort of remedy. And a lot of the early statutes, New York's, Connecticut's, focused, as we learned, on prostitution as the offense, right? Creating a way that survivors could go back into court and ask for the court to vacate or undo, reverse a conviction, a finding of guilt on a prostitution offense. We quickly learned, as you've already heard, that that was way too limited, that we needed these laws to be broader. The types of offenses that many of the survivors that we were working alongside had on their records ranged, and we needed the laws to reflect that. So we moved into sort of phase 1A of the effort, where we were looking at legislative amendments. States that were passing new laws took the lessons learned from our jurisdictions and went further appropriately. Actually, I see Jenny now, and I'm realizing I'm omitting Florida from our timeline. And Florida, to its credit, came in the middle of that phase 1A and enacted a very robust and strong law that we look to as a model in many ways for other states. And I believe that was in 2013. Jenny, is that right? Thank you. I know I should have this all at the top, memorized, but so where are we now? We know that some of these laws have been really critical for survivors seeking relief. We have vacated a number of convictions for survivors in Florida, in New York, in many states, but we're also recognizing that the obstacle that the laws present must be addressed. Through the Survivor Reentry Project, which started at the American Bar Association in 2016, we serve as sort of a clearinghouse, not just for lawyers working on this or lawmakers, but for survivors themselves. So we field inquiries from human trafficking survivors all over the country who have criminal records and don't even know where to start in terms of getting those records cleared. Most people don't actually know what appears on their criminal history. For people who are arrested multiple times and are dealing with situations of exploitation or abuse, that lack of information becomes even more acute. So the first step, where we start with people, how this works, is we just help survivors understand what appears on their criminal history and then what law might be available to help them. We field these inquiries, we created a network nationally, and that's again where I look to our attendee list and our participants and see so many members of that network. And anytime I talk about this, I also point out that I have a draft system for this network, and you have all been drafted involuntarily, probably, to be part of the national network to make this relief achievable. So in 2019, we took the 10-year anniversary of New York's law as an opportunity to reflect again on, okay, how do we keep improving this? And together with the Polaris Project, a co-author who's in the audience today, we set out to rank or grade every single state on the relief that they were offering to trafficking survivors. To get right to the heart of the matter, Connecticut failed. Don't worry, many other states failed too. We didn't actually grade on a curve. We decided against that, even though I am now teaching at a law school and I understand how important a curve may be, grade inflation. But we decided that it was important to be honest about this and to say, no, these are the principles, these are the parts of a law that we see as essential. This is where we're falling short, and this is what we need to do to close that gap. So Connecticut scored a 40, was it a 42, I think? Or it was a failing grade for sure. This legislation that we are discussing today would put Connecticut in the top 10 in the country in terms of the relief offered to survivors. So I think we just need to let that sink in. All of this, the offenses that are covered, the process itself, we need to be vigorous in making sure that a survivor going through this process is able to access relief without imposing impossible burdens, without causing additional harm. And the reason for that is this is all part of a reframing, it is a reframing. It's a different understanding of our criminal legal system and how it impacts people. For the first many years of anti-trafficking efforts, we just looked to the criminal legal system as a way to prosecute trafficking, right? That was where all the effort, all the resources, all the energy went. We can have a whole nother discussion about how that ended up and whether that's been good, bad. We may have different ideas about that. But what we know is during that time, people who under the law were victims of human trafficking were coming into the criminal legal system, were not being identified as such, were being criminalized, and were facing the heavy, heavy burden of sentencing, of criminal records, of criminalization. So a few points on the very specific questions raised about the Connecticut law. It is important that this law apply to any offense that a trafficking survivor commits as a result of being trafficked. The point about judicial discretion here is key, right? The law does not, in the draft form, particularly, mandate that anyone would have to have their convictions vacated for a felony offense or for any sort of offense. It simply gives judges the discretion to do so in a careful consideration of the facts. Giving courts discretion is not the same as giving people a get out of jail free card, right? Which I know is a concern. We want to make sure that the relief only is extended in the situations where it is appropriate and deserved, but the courts will be the check on that. Courts are able to do that. As Justice Katz said, judges make these kinds of decisions every single day in criminal proceedings. So this would be no different. There's a notion about floodgates, concern about perhaps a rush of applications or petitions if we do expand the law in any way. Our experience in every state in the country that has enacted more robust relief has not been that. In fact, more trafficking survivors remain completely unaware that they're even entitled or maybe eligible to do something about their criminal records. So most of our efforts are on raising awareness with survivor advocates, community-based organizations, right? That this even exists as a possibility. And finally, the question, I say finally, I think I'm okay in my 10 minutes maybe. Amazing. The question about trafficking offenses themselves, this is critical. This is absolutely critical. So many trafficking survivors are prosecuted for the crime of trafficking. We know this. Every prosecutor in the country knows this. We know it from the letters that I get from survivors every single day. who have been prosecuted as traffickers. Many have been prosecuted right alongside their traffickers. And the notion that somehow the criminal legal system is getting that right when the cases are first being prosecuted, we just cannot rely on that. We understand that the dynamics of trafficking in particular mean that people will not disclose necessarily at the time they are arrested and being prosecuted what is happening to them. In many instances, it takes a long time for them to be able to do that. So cases are resolved constantly without any safety net, without any check to make sure that that exploitation isn't happening and impacting conduct. We need a retroactive relief that takes that into account. The states that have offered relief to trafficking offenses, where relief covers trafficking offenses, again, have not seen the floodgates or an onslaught of petitions that simply aren't merited. It's just not going to happen. So I'm happy to talk about that or anything else more in Q&A.
Kate, you actually have 1 minute, and I'm going to use moderator privilege to ask you. I had three things I wanted you to touch on, and you did 2 out of the 3. The third
I'm
being
never going to be perfect.
No, listen, this is fantastic. Thank you. You really followed cues beautifully. Thank you so much. This is with regard to burden of proof. If you could spend a moment talking about your experience or recommendation as to what the burden of proof for this should be.
Yeah, this is a great question. So New York statute makes very clear that the burden of proof is preponderance of evidence. And for non-lawyers, that is a relatively lower burden of proof. It's hard to sort of articulate in terms of numbers. I know people try to a lot of the time, but proof beyond a reasonable doubt being sort of the highest level of proof, of course, that's the proof that we need in order to convict someone of a crime. But preponderance of evidence is the more appropriate standard here, which is a lower standard. And there's a couple of reasons for that. One is that to require a higher burden of proof would put an impossible strain on survivors. And as you heard from Teresa, right, finding documentation or being able to prove your own victimization, we have to think about what's realistic there, right? Many survivors will have had interactions with the criminal legal system, interactions with healthcare providers that show injuries or other things that support and show their exploitation and their victimization, but some will not. And we want to be very clear that we don't place requirements into a law that means survivors aren't going to be able to access relief. One of the very first cases that we had in New York, and I always have to talk about this case, was a survivor who was seeking to vacate over 80 prior convictions. And she did not have official corroboration that she had been trafficked. Many of the traffickers that were involved in her life, she only knew on a first name or street name, nickname basis. She didn't know their dates of birth, their social security numbers. She didn't remember exact places or dates. And the prosecutor in that case opposed vacating her convictions and said there just wasn't enough proof. So it went to a hearing and she testified at the hearing, which is something, again, we should talk about what we're asking people to do in order to vacate certain convictions. But she testified and the judge credited her testimony fully and said to require anything more than her coming in and just saying what happened to her and us to be able to sort of test it in that way would be impossible, right? Would be unattainable for too many trafficking survivors. The DAs in that case raised the sort of opposition was based in, well, if we grant here, we might have to grant in other cases, floodgates. And the judge said, we can't live like that. That's dogmatic, that's unpersuasive, and that's not going to dictate our effort to provide relief to survivors. Since then, that very prosecutor's office has changed its approach on these cases completely. It really forced a very important rethinking. And since then, they have consented to vacating of more convictions than probably any other prosecutor in New York State, any other county prosecutor. So I say that just to say that we need to be cognizant of some of the real life limitations of requiring too much from survivors seeking relief.
Thank you, Kate. To me, it begs the question of whether or not there needs to be a burden of proof articulated at all, but that's for our next speaker. Jenny? Thank you.
Great. Okay, I'm going to treat my 10 minutes like a time. I was in Miami doing a trial in an armed sexual battery, and the judge told me I had 20 minutes for my closing argument. So I managed to do that. I hope I can do this today, but thank you so much for having me. I'm the outsider here. I am a prosecutor in Orlando, Florida. I've been a prosecutor for 10 years in Orlando and in Miami. I've been handling sex crimes and human trafficking for a number of years now. And for the past 4 years, I've been the chief of the sex crimes and human trafficking unit in Orlando. And Orlando is kind of Florida is a hotbed for human trafficking. Orlando in the past few years has been as high as third per capita in the number of calls to the National Human Trafficking Hotline. And so there are a lot of people who have been victimized here who have sought relief. And as Kate said, Florida has this really robust human trafficking, we call it expungement, vacatur statute, which I'm happy about because Florida doesn't always do everything great, but this statute is great. And in my time handling we call petitions to expunge, I have stipulated to vacating convictions on behalf of 25 survivors and on hundreds of cases. And that is something I'm really proud of. And as a prosecutor, I think that we don't think of our job as being to vacate convictions, right? Unless you work in your office's conviction integrity unit. And I think that our job is to do justice, to get things right. And that is the perspective that I take to these human trafficking vacatures. It is just that. I really do get the same sense of justice from the role that I play in helping a human trafficking survivor have their record fully expunged, vacated, as I do in getting justice at trial for a victim of human trafficking. And so I think, I'm trying to bring the prosecutor's perspective here because I think it can be a scary thing, but when you view the lens, when you view a request to have a human trafficking victim survivor's record vacated through the lens of, if my office, if law enforcement who made the arrest or the prosecutor who charged this case had the information that you are getting now in the petition from the affidavit that the victim's filing, from all the information you're getting about their trafficking, if you had that information at the time, would you have filed these charges or would you have treated this person like a victim? And of course, the answer is no. Just like Teresa was saying, right? Nobody asked her why she was in these positions, right? And I think that is one of the reasons why these survivors were treated as defendants at that time. And the other reason is that, as Kate talked about, for so many victims, the point that they are ready to come forward with their victimization, it could be a year after arrest. It could be after a year of sitting in jail, a lot of distance and time between them and their trafficker. So I view this as righting a wrong. In Florida, when the conviction is vacated, we are saying that there was a substantive defect in the underlying criminal proceeding. It's not saying the prosecutor did something wrong. It's just saying that we have information now that is exculpatory, that shows that this person was not criminally responsible. And so we are righting that wrong. And I'm really proud to have played the role that I play in this. So I'm going to talk about, I had some materials, and two of the things that I provided were these letters. You'll see an apology letter and then a letter in response. And I wanted to use this as an example to kind of highlight the beautiful way that the expungement law in Florida can work. So I actually was prosecuting a human trafficker and his bottom. And I think probably most people here know the term bottom bitch or bottom, and that is, I'm sorry, Joette, you're shaking your head.
I'm sorry. Yeah, I hate to interrupt you. I'm sorry. I'm not sure everyone does. So I would ask you to please define it.
Okay, sure. So the bottom is usually a woman who is the closest to the trafficker, who may also have, a romantic relationship with the trafficker, but who is kind of like the number two and who helps the kind of trafficking organization run, who helps recruit other victims or other girls or people, who helps kind of indoctrinate them, make them feel safe and comfortable, provide for them as well, but also carry out the traffickers' coercion to keep that kind of enterprise going, to keep other victims working for them together. But the bottom is often a victim herself of trafficking, of abuse, of coercion. There's trauma bonding that takes place. And so a lot of times when we prosecute these cases, the bottom initially may be charged as a defendant, but ultimately may disclose that they were a victim themselves. And I have often converted that defendant charge to becoming a named victim in the case when that happens. So that's what happened in this case with these letters. It was, this person was initially at the time of arrest charged. She was unwilling to say anything that would implicate herself or inculpate the trafficker. She had a kid with the trafficker. She was pregnant with another of his children at the time that she was arrested. And she sat in jail for about 9 months. And I had made clear to her attorney, whenever she's ready to talk, I know she's a victim. And I'm here and the agent's here. And eventually she was ready. And so at that point, we resolved her case. She pled to a different charge and she went on probation and she entered a human trafficking residential program here. And she was doing great in the program. And after about a year in the program, she had a job. She was working on reuniting with her children. I got her petition to expunge all of her eligible offenses in Florida. And one of those crimes was a battery on a correction officer from 7 years ago. She was with a different trafficker, but she got arrested on a prostitution charge. She was high. She got booked. She got in a fight with a female CO who was probably searching her, and she punched this female CO in the face. So I reached out to this CO, not knowing how she was going to feel about the request to have the record expunged. But I had an initial conversation with this CO, and the CO was really not on board. She told me it was a moment in her life, in her career, she will never forget. Nothing like that has ever happened to her before. And she really didn't want this person to have it erased from the record. I thought it would be a good idea for the survivor, who I'll call M, to meet with the CO and be able to talk to the CO about where she was in life and what she'd overcome and what it would mean to her to have this charge expunged, the employment opportunities, housing. So we were going to do that meeting. COVID hit, we couldn't do that meeting. And so M sent this letter to the CO, and you can see the letter. And when the CO got the letter, I facilitated that. The CO called me and said, I 100% want her record cleared. Never before in my career have I had the opportunity to feel like I could make a difference in someone's life the way I can make a difference right now with this person who has overcome so much. And then the CO wrote a letter back to M. So you can see those. And for me, it was a really beautiful working of the expungement law. If this had taken place in Connecticut with the way that the law is being proposed right now, I think this charge might be one of those class A or B felonies, assault on a correction officer, and it might not be eligible. And so I was looking at Florida's ineligible crimes and Connecticut's ineligible crimes. And I think, to reiterate what Kate has said and what Joette has said, it's really important to think about the experience of a human trafficking victim and what they're going to be arrested for in that victimization, drug addiction, fraud charges, theft, and interactions with law enforcement that aren't going to go well because of their trauma. And then obviously trafficking. If that was excluded in Florida, then M would not have been eligible for the expungement. And I think to exclude that category of bottoms is, they're a really complicated group of human trafficking victims. And I think that they need to be included in relief. Both Florida and Connecticut exclude robbery, which I wish was included in Florida, because I think it's common for robberies to take place, especially in the context of a buyer. They'll kind of rob a John, and that may not go reported often, but sometimes those Johns get shot and then they do report it. So I've experienced that. And then I'm at 10 minutes, but if I can take one more minute, Joette, I just wanted to talk a little bit about my process. So,
Thank you.
Is that okay?
Yeah, absolutely.
Perfect. Okay. So eligibility in Florida, a victim can seek expungement once they cease being a human trafficking victim or have sought services. And then we also have that preponderance of evidence burden of proof. And I kind of just approach it like, how do you know that this really happened? So when Teresa was so eloquently and courageously, because every time that she has to share this story, I think it takes courage. When she was talking to all of us about what her experience was, I imagine that every single one of us believe her about what happened, right? And so I have this standard when I'm evaluating, but I'm just like, yeah, I know this happened. I know this because of the work that I do as a human trafficking prosecutor, and I'm constantly evaluating people's credibility. And so I know that this is real. There are times where I may want more information, and I can reach out to a task force to get more information, go to an analyst who can pull reports and see, where they pulled over at a time where they were with their trafficker, but usually I read a petition and I'm like, yeah, I know this is real, or I can sit down and meet with the person and talk to them. So another thing that I do is I file stipulations. I used to file a notice of non-objection, and then I was like, no, I want this to happen. I am filing a stipulation. So I included a copy of my stipulation, and I file that, and then I have to bug the judges to sign the orders, because sometimes, they're not even familiar with what a human trafficking expungement is. They have 50 orders to sign, and I want this at the top of their list because this survivor has waited years, however long, and they are ready for it. And when I'm filing that order, I have a section in my order about how important this is, that our legislature wants this signed and done expeditiously. And so I'm like hounding the judicial assistants to get this done. And so, and I've avoided hearings. We've never gone to hearing on one of my cases, and I think that's really important. I don't want to make a survivor have to get on the stand and have to talk about their traumatization. So I feel like I play a really active role, and it's one that I am really happy to play. And it gives me kind of the same prosecutorial fulfillment. And I feel like it is the same pursuit of justice that my job otherwise dictates. So thank you.
Thank you. Actually, I'm going to pull privilege again. And if you would just take a moment and talk about the defense of duress and why that's really an insufficient vehicle in these cases.
Oh, sure. I mean, I think because that is during the pendency of a criminal case, and also if the prosecutor on a case is one who has experience with trafficking, then they may understand that, and maybe the prosecutor will not go forward on a case. But if it's left to a jury, that is such a wild card of an outcome. And a defense of duress in a drug possession case or a theft case or something like this, with kind of prosecutors who are not in the world of human trafficking and understanding the dynamics, I think would just leave survivors at the whim of people who maybe aren't well suited to make that determination. And I also think it's important that every kind of state attorney, prosecutor's office, DA's office, that is handling these should have somebody who is really familiar and understanding of human trafficking to handle these requests to vacate. So I do all of the requests for my office. I'm the chief of the human trafficking unit. So I think that's also really important.
Thank you so much. Appreciate it. All right, our next speaker is Chief State's Attorney Rich Colangelo, and there's been one instance, to my knowledge, where our existing statute has been applied to vacate, and he was instrumental in doing that. So if I can turn it over to you, Rich.
Thank you, Justice Katz. And I want to start with thanking Teresa for being courageous and, coming forward and telling us her story, because it is not easy for her. And I know that, and I know that she's reliving it over and over. But just going off of, and I kind of want to play off of stuff that Kate and Jenny have said, and Teresa was very clear in saying that no one ever asked me about what happened. And no one asked during the process, during the pendency of her cases. And I think it's important to highlight that if Teresa was asked during the pendency of those, I don't know if she would have told us at that time and kind of said that, hey, this is what is going on. Please help me. It is a process. It is, it does take time for the victims to realize what's going on in their lives and to actually be courageous enough to say, hey, I need help. And who are they going to trust to get that help? And as prosecutors, I think that to kind of echo what Jenny said, right, we have to be instrumental in that. We take an oath to seek justice. I'm happy to say in Connecticut that we have prosecutors in every office throughout the state that are kind of the trafficking liaison for each office. So they have that training, they have that experience, they have the ability to network and work with each other to get the information they need to make these decisions. The case that Justice Katz talked about, it was something that I actually was part of just last March of 2020. I was appointed as Chief State's Attorney in the end of January, and I was still acting State's Attorney in Stamford. And a victim of trafficking came to me through an attorney through New York to say that, hey, I have a prostitution conviction. And it was, looking at the paperwork that they filed, it was kind of a no-brainer because as Jenny said, right, we want to make sure that there's confidence in the system. And if you look at that conviction, as a prosecutor, I could say that, hey, I don't have confidence in this conviction anymore. And I think that, we should do something about it. In listening to, Kate's points and Jenny's points about what should be included. And I know that sometimes, if it's included or not included, we in the system look to do what's right. So if a victim of trafficking came in and said, I have a trafficking conviction and this is what happened, even though it's not part of the system, it's part of the statute, even as it's proposed, I would hope that a prosecutor would look at that and say, hey, you know what, this has some merit, Judge. It might not apply right now, but you still have the ability to do it. And we bring it to the judge's attention and have that included in that situation. So that's something that, I hope that we're able to do and we'd continue to do, to have the confidence in the system that the convictions that we have throughout the system. I just wanted to make sure I was touching on all of the points that I wanted to cover. Just one thing, Kate, Connecticut got a 45 because I'm one of those people that wants the curve. I needed the curve to get through my education, my engineering degree. I didn't get it. I got it through it. That got me through the UConn engineering. But yes, the point that Kate was making is we have to do better, and I think that the proposed legislation here allows us to do better, and I think it's going to allow us to have the ability to have the confidence in the convictions that are there. And if the victim is strong enough to come forward and give us that information, we have to look at it and run with it. The thing that struck me, when I heard Teresa speak the other day when we were prepping for this, I think I thanked her for and apologized to her for having to go through the process she had to go through to get a pardon. It's not easy to get a pardon. I mean, it is arduous, it is time consuming, and there are a lot of hoops to jump through. And as Teresa said, that, people are, they give up along the process. And I'm glad that she didn't. And she was able to, she had the strength to do that and to continue and was able to actually, share with us today. So those are that's where we are in Connecticut, where I hope we're going in Connecticut. Did I cover everything you wanted me to cover, Justice Katz?
For now.
Perfect.
Okay, thank you. Our next speaker is Jillian.
Hi, everyone. Thank you so much. I'm State Representative Jillian Gilchrist, and I also chair the state's Trafficking in Persons Council, which is a great honor to get to learn from so many subject matter experts across the country and here in Connecticut. Thank you, Sheila, for bringing us together today, and Judge Katz for ushering us along. And to my esteemed panelists, in particular, Teresa, thank you for sharing your story so that we can be informed and learn more. So I want to give a little background on where Connecticut's been, and ideally, based on what you've heard today, where we're going. To me, I believe firmly that policy and cultural change go hand in hand. And so the first federal policy regarding human trafficking was enacted in 2000. In the state of Connecticut, it was 2004 when we established the Trafficking in Persons Council, and then 2006 when we established our felony charge of trafficking in persons. And so I set that stage because really our understanding of human trafficking continues to unfold. And I see this piece as a next step in that process. And so it wouldn't be until 2016 when we would learn that we hadn't had one conviction of human trafficking in the state of Connecticut, even though we passed that felony charge in 2006. And so we came together again in the state of Connecticut to better understand why that was. We updated our felony charge, and I am proud to say that we have had convictions since then. We have a much better understanding of domestic minor sex trafficking in the state, in large part because of the amazing work that Judge Katz did when she served at the Department of Children and Families. We have educated folks on the hotel industry, not the good actors, but the bad actors in how they play a part in human trafficking, and have made a tremendous, have done tremendous work here in Connecticut, but nationwide, to lead on training efforts and requiring signage be put up not only in hotels, but at various locations where we know human trafficking takes place. And so, as I said, I do see this as a very important next step. So to give some context, Connecticut did pass, as I believe Kate mentioned, our first vacatur law back in 2013, which was specific to prostitution. And then in 2016, we did go in to update it, but unfortunately, we did it wrong. And so as currently drafted, that policy, the intent was to expand our vacatur law to include many of these other offenses that you've been hearing about today that we know, unfortunately, victims of human trafficking are arrested and prosecuted for. But we need to go back in and fix that statute because it actually does not give judges discretion. And I do feel it is imperative that we ensure that judges in the court system here in the state of Connecticut have that discretion. And so I stand with my other panelists in urging how important it is that we get criminal record relief for victims of human trafficking here in the state of Connecticut. The proposal that was on the table last year regarding this subject, which of course, unfortunately, got halted as a result of COVID and the 2020 legislative session coming to a halt, wouldn't have included Class A and B felonies. And as you've heard today, I feel personally as a state representative that including Class A and B felonies would be vital because we're hearing about these robbery charges, we're hearing about these various drug charges that wouldn't fall under the proposal that was on the table last year. We also heard from Jenny about this terminology called the bottom. As someone who's done victim advocacy during my career and has worked in gender-based violence for some time, a trauma bond forms between a victim of human trafficking and their trafficker. And so in that trauma bond, in an effort to please that trafficker, that individual might help in the recruitment. And so if going forward, our proposal does not include Class A and B felonies, I would like to see it at least include the crime of human trafficking, which I think can be really confusing for folks who don't do this work day in and day out, because they might be saying, why in the world would you, who advocate for preventing and prosecuting human trafficking, want to allow someone who was convicted for human trafficking to be vacated of that charge? But as you've heard today, traffickers use their victims to recruit other victims. And so I think the very key piece of this entire proposal, and why I feel confident that we could include all Class A and B felonies, is that we are giving the court discretion. And so judges will get to review that evidence, and this at least gives victims that opportunity. I'll close by saying it's been brought up, the pardon and parole process. Why not just use the process that one of the processes that we already have in place? And that's a common thing that comes up when we're discussing public policy. And so I'd like to address it because I know it will likely come up in the legislative session. Well, you've heard today that that's just not the right process. The vacature, what we've been discussing, there'll need to be a look at the evidence, and that's not the role of the Board of Pardon and Paroles. The role of a Board of Pardon and Paroles and an individual who is seeking that remedy is coming with contrition, right? They're coming to apologize for what they've done. But what you heard from Teresa, and thank you, Teresa, what you heard about the shame she experienced in going through that process, after having worked for years to understand that what happened to her was not shameful, that it was not her fault, that she is a survivor and she was victimized. To make a survivor go through a process where they then have to stand before a panel of people in front of a room full of other people and apologize for something they've now come to understand was not their fault is not where I want to be as a state. And having again done the work in the fields of sexual assault, domestic violence, and human trafficking, sadly, we know it takes years for someone to understand that they have been a victim of a gender-based violence crime. And so to Kate's point and to our chief, Rich's point, sorry, I can't get the title right now. I too like to see us be a leader. And we do have a weird competition, not only with New York, but Massachusetts. And so I would like to see Connecticut be in that top 10 for doing what's right by victims and leading with public policy. But most importantly, it's because we know it is the right thing to do for survivors here in the state. So thank you for the opportunity to be here today.
Great. So we actually have plenty of time for questions, but before I open it up and consult the chat room, I just wanted to give everybody, because we do have time, 1 minute to comment on each other's presentations and anything that you feel has been brought up that the questions from the panelists may not, from outside the panel, I'm sorry, may not give us an opportunity to address. So going reverse order, Jillian, is there anything that you would like to comment on that any of the other panelists has brought up that you've not considered?
Yes, thank you. And I wish I knew the answer, but I didn't, and I am a question asker. So does the proposal we're looking at include the preponderance of evidence? This would be over to my partner, Sheila. Okay, so could you explain a little bit about that?
No, right now the statute is silent as to what the standard and burden of proof would be. And I can put the current statute in the text if that helps folks.
Anything else, Jillian?
No, that was it. Thank you.
Okay, Rich?
Nothing right now.
All right. Jenny?
No, I don't have anything right now.
Kate?
Of course.
Good.
So a couple of things. I think just on the question of burden of proof, Justice Katz, your point was a good one. Why this kind of raises or begs the question, do we need one at all? And I think as lawyers, we're trained in such predictable, boring ways to sort of like take what we see in other places and just dump it in and write all a formula or a program. But I think this might be the kind of thing that courts can just do and figure out without an articulated burden of proof. And so I don't think we need to be bound by New York in that way, where the burden of proof is articulated in the statute. So I wanted to say that. Do you want to, I saw you open your mouth. So yeah.
And Polaris will not hold it against us?
Well, we'll have to think about that. We're going to think about that.
All right.
We might have to seek a pardon as to that particular category.
Kate, I need those points, Kate.
We'll curve for that, but we might have to reconsider that category. And really what this was, the reason why that category is included is to prevent against unsustainable burdens on survivors, right? Not to go in the other direction, to sort of say, we know what we're doing here, we trust courts to do this, so this is okay. So let's talk more about that. I think that's a really interesting point.
Well, and what I was thinking about, just so you know, is just sentencing. I mean, when judges impose sentencing, it's got to be reliable. I mean, there's got to be a foundation. I lost this case before what then became my colleagues at the Connecticut Supreme Court, State versus Huey, going back probably 30 plus years. There are some advantages to being old. You could draw upon these experiences. You know, and really it was a question of whether or not the court was considering certain material for purposes of sentencing. And the Supreme Court said, yeah, it's really an issue of whether or not this is reliable. So I just bring that up as a point of reference.
It's a great point. And it does sort of intersect with some of the other work we're doing in New York for domestic violence survivors who are in prison or facing prosecution right now. So I love that. And I would love to expand that conversation, but I know we don't have time right now. So now I'm well beyond a minute, but I'm not going to stop because I think, just to return to the offenses eligible, the included point, and Rich, to your point, yes. If Jenny Rossman were the prosecutor that I worked with on every single case, I have no doubt that we would reach just outcomes all the time, that we'd be able to walk into court and sort of tell the judge, this is what we're doing, like we all agree. But we can't legislate.
What about me?
Right? You know, we can't.
You didn't loop me in with Jenny.
I haven't had a case with you yet, Rich. We'll get there. We'll get there. But the point is, right, we can't create legislation that depends on that level of sort of thought, collaboration that we just know doesn't exist across the board, even with our best efforts. Even with our best efforts. This is not because there's necessarily bad actors, but we know that bad outcomes happen everywhere, and we have to give the remedy. And actually, there was an instance in New York with that same prosecutor's office I mentioned earlier that had a real turnaround in its policy on this. They had a survivor who had been convicted of an ineligible offense, and they were agreeing to vacate the conviction. And they went into court and they got that judge, that one judge that we all know is in our county, is in our whatever, that one judge that was like, no, I'm not doing it. I don't care that everyone agrees, and I don't care that no one's appealing, and I don't care that it's the right thing. There's no legal mechanism. So we have to prepare for that scenario rather than just depend on our ability to kind of get it done in the situations where, you know, we're going to get it done anyway. There was something else, but I'll let it go for now because I see such rich questions in the Q&A, and I want to be sure we get to them.
And finally, Teresa, anything in 2 minutes that you'd like to comment on that you've heard from the other panel?
Sure. One of the things that when we look at, you know, we were talking about the survivor coming in and out of prison again and again and again. And I think that, you know, there's a cycle that's happening. For example, so the survivor goes to jail. Okay, so the survivor goes to jail. Now, there's a level of dependence there. I need him to send me money. I need to survive. And, you know, if it's a year or two, all of a sudden you come to the end of your prison, a month or two before the end of your sentence. You start getting letters and money's getting put on your commissary. And, you know, Teresa, we can't do this without you. And, you know, the girls are going to end up getting in trouble. And, you know, it's just, you were the best at what you did. You got to come back to us. So there, I've been in prison now where I've basically, for a year or two, been told that I'm crap. And now someone needs me. Now I'm more than just the girl standing on the corner. And I know that there was mention with the bottom. I think that there is I think when it comes to that situation, that I've been in that situation. You just don't know what you're doing. You want to help the girl. You want to save her so she doesn't end up doing the things that I've had to do. And I think that something that has to be considered is just because she comes out of jail and does the same thing, he's already been in action. He's already said, I need you. Commissary, money's being put on your commissary. Phone calls, the whole romantic, how good we were together. And that is exactly the cycle. And then you go to jail again. And a month or two before the end of your sentence, the money starts coming. Call me. I'm lost without you. So I really want to just, there's something else, but that's okay. I just really wanted to let you guys know what that cycle looks like when a woman is incarcerated. That's all.
Thank you very much. All right, I think we're now going to turn to the chat room. And Sheila, that's where I'll find the questions, correct? You're muted, Sheila. I'm
So
sorry.
we had a question about what kind of evidence you have submitted in some of these cases, to the extent that there is evidence for people who are working with victims, for people who may be defense attorneys, for prosecutors. What does that look like?
To me?
Joette, I'm happy to send it to anyone, but Kate, go for it.
Sure. I mean, I think every situation is different. And so we have to become comfortable with the notion, as I said, that just someone's experience is going to look right. And some of these cases in situations we're going back years. So the notion that there's evidence or documentation, we have to sort of think through that. In some cases, there are, as I mentioned, court documents, police reports, medical records, photographs, but we also rely heavily on affidavits or letters of support from community-based organizations, from service providers who have worked with someone. We sometimes, depending on, again, the individual situation, have affidavits from people who would constitute witnesses, maybe family members or other people, but that's also not always the case. So every situation looks different. We're really only limited by creativity and then listening to the experience of what someone has been through and what we can find. And then we go back and forth between, when we started doing these cases in New York, we went over the top. I mean, we were submitting basically encyclopedia length pleadings that were really difficult for the person seeking relief to go through. I mean, similar to what Teresa was talking about at the beginning, but also just sort of making more work than we needed to do. And so focusing on what's important, how do we show the force, the fraud, the coercion that someone experienced? And then, how do we show this is an appropriate fit under the law without maybe going as far as we went back in 2010, 11 in New York State, that made the process, I think, a little bit more cumbersome and lengthy than it needed to be.
And Joette, I don't know if you want to add to that.
Well, I can tell you that there was a young lady when I was DCF commissioner whom we were treating, and she had a $sign tattooed on her face. And frankly, I would suggest, and not to be melodramatic about it, but frankly, talk about res ipsa. I mean, I would suggest, to Kate's point, every case is unique, but under those circumstances, I would hope it wouldn't take much more than her merely appearing in court to be able to demonstrate her entitlement. Thank you.
Well, Jenny, you want to jump in first, or you want me to?
Go ahead, Rich.
Ladies first, go ahead.
No, you go.
It is the case that I handled in Connecticut. It was an affidavit. Having somebody go through the story, as Jenny said when she was first addressing everyone, having the experience in dealing with these cases, you kind of get a sense of, it sounds right. I wouldn't have to look at that person, Justice Katz, right, to say that, hey, you know what, this information it rings true. Maybe we need to do a little bit of investigating, like Jenny said, to get the police report to show, were they together? Was there any connection between the person they're saying the trafficker was and the acts that we're talking about? But it's not, it shouldn't be that difficult. It really shouldn't.
The only other comment I wanted to make is that because, and Jillian talked about this, sometimes it takes years as we know, for victims to really to be able to acknowledge what has happened to them, let alone seek relief. And so in terms of whether or not that evidence is still available, those witnesses are still around. I mean, it's like anything else with the passage of time. I mean, that's why we have statutes of limitations. So as a practical matter, it may in fact be very difficult. And you don't want to make it so difficult that the statute doesn't get used, which is the present situation, quite frankly. So it's great to have a statute that is wonderful, but in terms of its application, if in fact we make it too Herculean a task, then we're back where we started.
And Justice Katz, we also had a question about the victims and what do the victims look like in these cases? Have there been analyses of what the race of the victims are, what the gender, sexual orientation, what are your victims looking like? And I'm also curious how you're finding them, given that they may come from vulnerable backgrounds where they're not really able to come forward on top of the fact that they've been trafficking victims and have been in the shadows for so long.
Well, it's funny, you should ask. My statistics are because I haven't been commissioner for 2 years, but while this panel was going on, I received a lengthy email from somebody who is doing the work still back at DCF. And I am just in a nutshell, increase in the substantiation rate, because that's really what you want to make sure you can do for human trafficking cases, is increased exponentially in 2020. 40% of human trafficking cases that came in as of 9/30/2020 were substantiated compared to only 10% last year. They've not yet delved into the question of schools, what schools, et cetera, where they came from. But I can tell you that practically speaking, most of the cases, 1,000 or plus that we were able to identify, I mean, that's the key. It takes a very long time. Love 146 can I think give us some significant information about that, the composition of who these victims are, along with DCF, which does keep data on the subject. I'm not encouraging a FOIA. I can certainly get it for you. I think there are boys, they are underreported because of the shame associated with that. They're called, they call it survivor sex when you're talking about young males, but in effect they are, and I think Teresa even told us about her brother. So we know that that's true. I will tell you that at last time I looked at this data, over 60%, and this is shocking to most people, over 60% of the youth who have been identified were living at home. So this myth that these are all runaways, that all these kids are in foster homes, that nothing could be farther from the truth. And I think 60% actually is an underestimate, quite frankly.
And I'm curious to know in other states. Yeah, Kate, what your
one of the important things to consider also is, I mean, there's of course a focus on youth and how this impacts youth, but we have to think about adults as well. And what we understand is that adults that come into the criminal legal system are overwhelmingly people of color, right? This is not a surprise to anyone. When we think about the class and race implications of who is prosecuted and then who carries the burden of criminal records, we have to talk about race. We can't have this conversation without that. And so when we also think about human trafficking just as a phenomenon, what we understand is that human trafficking capitalizes on vulnerability. And who is most vulnerable to exploitation? And vulnerability is created in a lot of ways, but one of those is marginalization by race, by class, by gender, right? And other forms of oppression. And so always important to note, we all kind of get stuck in whatever we do every day from 9 to 5, or many of us 9 to 9 or 9 to no, always. If we work primarily with youth, if we work primarily with foreign-born individuals, if we work primarily, with LGBTQI commercial communities, if we work, right, but this is just encompassing them all. And the commonality is vulnerability, and vulnerability through marginalization, whether that looks like family dysfunction or an unsafe home or housing instability or many other things. So, and I think the other piece of this, which we haven't touched on, is we've talked a lot about sex trafficking and trafficking into prostitution. We have not talked about other forms of trafficking and exploitation in other labor sectors. And so it's really important to understand that labor trafficking which exists in every sector, basically. But again, the focus on vulnerability, right? Who is vulnerable to exploitation can also lead to criminal legal system involvement. And so a remedy like the proposed legislation that applies to both sex and labor trafficking victims is critical, because just like sex trafficking victims end up prosecuted and with criminal records, so do labor trafficking victims. And so the remedy needs to extend there as well.
And I just would like to note for the record, there's a lot we have to fix, as Jillian said, but the current statute already includes labor trafficking victims. But I think, as we all know now, you're not seeing a lot of prostitution convictions in the area, not always with labor trafficking victims. So it's really not helping them at the moment. Can I just follow up on that for anyone who wants to respond? But somebody specifically asked, what does this look like when you bring, for example, a victim who's male? Because we know, as Justice Katz says, they're out there. They're maybe more hidden in some ways. And so how does, I guess, race, but also gender and sexual orientation, do you see an impact of that as you're bringing these cases?
Jenny, how many male victims have you had? I know in Connecticut, one of the convictions we had was for male victims of trafficking. That was one of the only, it was after trial.
Yeah, I mean, as a prosecutor, so with human trafficking cases for the past 4 years, I actually have filed criminal charges for 0 male victims. We've investigated some, but not filed charges. And the like 25 or so survivors that I've stipulated to, or that expungements have been granted, those were all women as well, and adults, because juveniles have their own. So all of those were adult women. And like I couldn't accurately give like a statistical analysis of breakdown of like race or ethnicity, but I would say like it runs the gamut: white, Black, Latina, and Asian, probably here.
I would just add that because many states, at least as far as DCF is concerned, don't get involved in these cases because the youth is being neglected and or abused by somebody who's not responsible for them. And so as a consequence, there are jurisdictions that do not consider this to be part of their responsibility. You call and DCF says in many of these other jurisdictions, sorry, we really can't help you because the abuse and neglect is being perpetrated by somebody other than a parent or guardian, as obscene as that sounds. So that was really the first thing that we did in 2011, is to get the legislature working with them to allow our statute, and not just for fiscal reasons, but for humane reasons, quite frankly, to allow us to be able to accept these cases into the care line, then known as the hotline. And that's what I was talking about in terms of the investigation and substantiation. So I don't know what you'll see nationally. And so to your question earlier, Sheila, about how do you identify these, we encourage people all the time. We were trying to get into schools. We were working with police departments. I mean, Jillian referenced some of the work that we've been doing to get people to understand, if you see something, say something, but do it in the context of youth that you may feel have fallen into the life.
And that is huge. I mean, you're just dealing with and training law enforcement, right? I mean, even patrol division, you pull somebody over, you see somebody in the car that doesn't look right, ask the questions, right? Because I mean, if that happened with Teresa and somebody asked, maybe she would have been able to tell somebody sooner. And that's something that, with prosecutors, whenever we're doing any trainings with law enforcement, we're bringing to their attention, just don't, okay, I pulled you over speeding, here's a ticket, look around a little bit, do your investigation. If it doesn't seem right, ask some questions.
Great. Cindy Will, my student.
Can I also talk about identification as just for one quick question?
Perfect.
Another really important piece of this, I think, is collaboration with community-based organizations and sort of agencies or organizations most likely outside of the systems that are themselves, right, sites of harm in many ways for families, communities, and individuals. And so we are all, I think, individuals that are deeply invested in making our systems better. But as that is in the process of happening, there are still many people who view systems with distrust, from the healthcare system, education, child welfare, right? All of that again, just we have to make sure that there are resources outside of these systems And that then people are looped back in for the assistance or resources that they need. And so through Survivor Reentry Project, almost all of our referrals come from community-based organizations that are working with survivors. And that, I think, is a critical piece of the partnership, no matter where you're standing.
And Anne-Marie Boulay is evidence of that. Her work at the underground has been tremendous. Thank you.
I mean, this whole discussion also makes me wonder about specialization and what your states are doing and what may be a good model for Connecticut, because I think there's the opportunity to have maybe a judge who specializes, a prosecutor who specializes. I mean, who is going to represent these people? How difficult is that process if they're even able to come forward? The first big step, but then going before a court and trying to navigate this process. Teresa said she had a senator by her side, helping her with this. I mean, that is a huge hurdle. I'm wondering if you can talk to that. And I think Cindy also had a question after this one. Jenny, I don't know if you can talk to that, how your system developed.
So regarding specialization, so the majority of relief requests, petitions filed that I get come from a particular pro bono legal nonprofit organization run by an attorney named Brent Woody, and this is what he does. And he does it around the state of Florida. And the various, community, nonprofit, anti-human trafficking organizations, whether it's the residential programs, the various other organizations, they all have his contact information and they put survivors in touch with him. And so he files petitions around the state of Florida. And then there's like a pro bono attorney at a big firm in Miami, and there's another, attorney who used to be a prosecutor who files. And I feel like all these people have been trained by Kate at one time or another in terms of like how they best do this work. So I would think like somebody in Connecticut should step up and make this their mission. This will be what they do. They're going to be the kind of pro bono attorney to file vacatur petitions for human trafficking survivors, because I think that has to be somebody's specialty. I've tried to talk to our public defender's office about, I would love to do a training for them about what this relief is so that they can tell their clients, they can talk to their clients who have been arrested on prostitution charges or on drug charges or other charges where they see a record of prostitution or suspect, trafficking. I think that we could do a lot of community outreach about this as well. And then, yes, it would be amazing to have a human trafficking court, because right now it's whatever case, whatever judge or division that they hold that that a case was resolved in front of, that is the judge who handles the request at this time. So, in any courthouse that involves so many different judges, and this is a specialized thing, the way there are specialized domestic violence courts and other things. And I already talked about, yes, I think that there should be a specialized prosecutor for sure. I think it would be great. I think it's a wonderful aspiration. I would love to have that here where I am.
A few ideas that I'm also offering to help with should this law pass and we move towards implementation, in a more robust strategy around that. In New York, our biggest success was through the partnership of the public defender's office and the pro bono legal community. So in terms of the training that Jenny mentioned, but also then getting some of the resources of the pro bono community. And there are some things to be aware of, some things to think through, but I think that's a very promising possibility, particularly in Connecticut. And then for court adjudication of petitions. So as Jenny mentioned, sort of thinking about the judge and who this is going to be in front of. We have 62 counties in New York State, and there's very different practice and culture across those 62 counties. And so there's the New York City county, right? And I think thinking about what this is going to look like everywhere. So there we have been trying to figure out sort of hub courts for this that would again centralize and codify that specialization. Particularly for regions that have parts of the state that have less resources, less education around this, and need some help kind of implementing. So all of those things are possible and should be explored once we get a law in Connecticut that allows survivors to actually seek real criminal record relief.
Cindy, do you have a question from the chat?
Yeah, so we had a question, which I think Jenny and Kate could answer, and then Jillian and Rich could answer to see how it could be implemented in Connecticut. But it's, have you thought of other components like confidentiality and official documentation that are neglected in both the old and new suggested legislation? This person said that additionally, states are now adding interesting components like the return of fees and fines, and allowing survivors to go through one process for multiple convictions in different counties instead of going to each separate jurisdiction. So I guess, Kate and Jenny, how has that worked in New York and Florida? And would this be able to be something that we could implement in Connecticut?
I'll go first, Kate. Okay. Yes, that's a great question. Okay. So when a petition is filed by, the attorney on behalf of the survivor, they will file always a notice of confidentiality of all the filings, exactly for all of the kind of common sense reasons that we would never want anyone, especially anyone involved in the trafficking of that survivor, to know that that survivor is now seeking expungement. And that petition, if a form of that affidavit were to go into the court file, usually it's a very abbreviated affidavit that is filed with the court, but what is sent to me, that would 100% need to remain confidential. So that is done routinely on all of these cases. I incorporate, I think in my stipulation, it should, but like more recently, I have incorporated that I am stipulating to the return of fees under that United States Supreme Court case. So that is something that is being sought on the majority of petitions. And if it's not asked for by the attorney who files, I will say, hey, throw this in, let's throw this into the order. And then unfortunately in Florida, only one court can grant relief at a time. And so, right, they might have been trafficked in Orlando, and then they might have been trafficked in Miami and in Tampa. Those petitions all have to go through a separate office, and they can't be pending simultaneously, which is dumb, right? That should be fixed because it could take years for one to resolve and the next one to get filed and the prosecutor to get to it. And, because obviously that's not the only thing that anybody's doing. So that would be great. It would be great if it could be one jurisdiction in the state could handle all of the matters around the state. Maybe the different prosecutors' offices would all be consulted and work together and contact their victims if there were victims on those cases, and then get back and file a joint filing from all the offices. But so there's still ways to improve.
Yes, I suspect I know who asked that question. But what I will say is even in places like New York and Florida, where we've sort of figured out the confidentiality issue by doing additional filings or by using other provisions of law that are sort of adjacent to this, but don't really line up exactly. When we wrote the report analyzing state law, we made it a key component that the criminal record relief laws themselves say information provided to the court as part of these petitions is confidential. I think it's the safest way to protect survivor information. There's no reason it shouldn't just be in there. This is not a particularly controversial point at all. And it makes it clear. Again, I feel like I'm always kind of bringing out the lowest common denominator and the worst of our practice, but we have to, right? Because we know that that's what people experience. And so for lawyers that don't know to do what Jenny described, or know in New York to go to the civil rights law that protects information, we want the law itself to be clear and almost an instruction to protect survivor information. So that's about confidentiality. The consolidation of motions across counties or jurisdictions within a state would make survivors' experience so much better, unequivocally. The only state that allows this right now is California, with their revision to their law in 2017. And it's turned out to be a lot trickier in terms of actual implementation than anyone thought. So again, important, and we need to think through what it would look like in a state like Connecticut. In New York, we have a unified court system that is in no way unified at all. And so to do this in New York would be, even though we're considering it as a legislative, like we have pending legislation that does this right now, thinking about how it would actually be put into practice makes my head hurt a lot. Thinking about the individual clerks from each county, individual prosecutor, and all the sort of coordination, where these files even live, all this stuff. So there's a level of complication here that I don't want to gloss over, and I would hate to get in the way of any, of any meaningful effort. And so it's just something to think about. And then finally, the return of fines, surcharges, fees paid by someone when they were prosecuted. Again, this is not controversial because the Supreme Court has said when you vacate a conviction, you have to give the person the money that they paid back. So there's no way around it. It's not specific to trafficking survivors. It's not specific to this law or any, right? So, I mean, from even in New York courts, the Supreme Court still gets to say kind of what happens. So with that decision of Nelson versus Colorado, which the question referenced, I think states don't really have, there's nothing to discuss. They just have to do it. So on the other hand, for those implementing the law, thinking about the procedure, how will that work? I've gotten many frantic calls from clerks across the country saying, what am I supposed to do? I don't know. You have to figure out how to do this. So whether that's in the law itself or not, again, it just has to happen.
Jillian, you want to
We
jump
have
in
a
first,
pretty
or-
bare bones. Oh, sorry. Go ahead, Rich.
I don't know, Jillian, do you want to talk about Connecticut first, or?
Yeah, please go ahead.
All I'll say is this is very helpful. I appreciate the question because I hadn't thought about these things, and would love to hear what you have to say, Rich. I don't know if we would be able to in Connecticut have it be one filing.
The confidentiality is really easy. The way Connecticut is set up, I mean, 13 different judicial districts with the state's attorney in charge of each one. So that's a bigger lift in Connecticut. And I know each one of them would be, happy to look at this and do the right thing on them. So, but it might have to be in separate jurisdictions. They handle each separate because of where the paperwork is, where the crimes occurred, where the convictions occurred, and that's probably the best we're going to be able to do in Connecticut. But it's worth looking into and talking about.
But at the very least, it could be simultaneous.
Absolutely.
Yes, I should have pointed out that Florida is unique in this way, and that Florida requires one to be completed before another application is filed. That is a huge burden that does not exist anywhere else. So yes, I think you can be working on petitions in different counties or different judicial districts simultaneously. That is the way we should be doing this. Florida just has a very weird quirk to its law.
Hey, did Jenny get points off for that?
Yes.
Good. All
Don't
right.
worry.
And I wanted to jump in here following up on this. And again, Connecticut's law is pretty bare bones. There is no standard for a burden of for how much, to what degree the applicant needs to show that they are a victim of trafficking. The other piece is that it allows for prosecutorial notification, but does not require the prosecutors to weigh in. And it's interesting, we have a question from someone who's a prosecutor in Pennsylvania saying it requires the consent of the prosecutor in order to file vacatur. How would you respond to a prosecutor who says that my client is not worthy of the remedy?
As Jenny said, right, confidence in the convictions is huge for us as prosecutors. I mean, that's a big part of what we have to do in the system. So, I mean, that's where you start. I don't think the prosecutor should be the gatekeeper for it. I think Justice Katz is correct. I mean, these are things that it's a decision. Look, ultimately, a judge sentenced this individual. So a judge should be the one that makes a decision on whether that sentence is vacated or not. And that's, why I looked at Connecticut's law and said, this makes sense. And if a prosecutor is doesn't see it, then it's going to be up to the victim or their attorney, unfortunately, to kind of open their eyes and let them understand that, hey, this is why the confidence in this conviction is, not there anymore, or information we didn't have before. Sorry, Jen.
Oh, no. Yeah, I've literally not, at the point that a petition is filed with, with my office, I'm usually kind of aware that it's coming. I've talked a little bit to the attorney ahead of time. And for a true survivor of human trafficking, I just can't picture that. And, but I mean, here, the same thing would happen with Florida's law, that, you know, the judge is the one who grants the request, who signs the order that then directs the kind of destroying of the records by all of the various agencies. So the prosecutor is not the gatekeeper. I just think the model is that, you know, the prosecutor can be like the Sherpa or the, you know, usher to like make it happen. Like that's the role that I welcome. And I think that it does take a reframing of sorts as the prosecutor. And there's even like a moment where I was hesitant, which was something that Kate, through the project at the ABA, brought together a number of prosecutors from around the country to discuss vacatur a couple years ago. And I brought up, what happens when we get a request for relief while a case is pending? I am prosecuting, this is my charged victim, and she is requesting relief right now because this case is not her whole life. That was a piece of her life, but she also is a mom and she has kids and she wants to get better housing for them and she wants a better job. And who knows when this trial is going to take place? I mean, imagine with COVID, right? Or whatever. And I'm like, no, I'm not going to throw out that impeachment evidence for this victim, that I am the same person who is expunging her record. And defense is going to be like, well, that's the only reason that she's saying that she was victimized, that this was coercion, right? And another prosecutor who's handled these for a long time in Manhattan was like, Jenny, you need to look at it differently. That helps you. You would then have an order from a judge saying, this is a victim of human trafficking. I certify that she is a victim of human trafficking. She is eligible for this relief. Like, you don't have to be worried about the impeachment. And I was like, oh my gosh, I so like, I was not ready at that point to stipulate. And then I was like, you know what? I'm going to go in there and I have this different view and I'm going to own it. And so I did expunge while the case was pending. I told defense, I got this expungement petition. I am going to agree now. Obviously, I believe she's a victim of human trafficking. She is a victim that I charged on behalf of, and that's where we're at. And I was like, if you're going to bring that up as, you know, impeachment from the moment that she filed this, I think I'll be able to bring in her prior consistent statement that she gave 2 years ago to law enforcement about her, her victimization. So I used it as, you know, I flipped my view. So I think as a prosecutor, you're always kind of going to be able to see things differently, and you need to be open in this area and in other areas.
So I would just say I love the prosecutor as Sherpa analogy. I'm going to maybe use that in other contexts. But I think this is it. This is about sort of the binaries that we're forced to adopt in the criminal legal system, you know, victim, defense, right? Like the labels, the binaries, and even thinking about Jenny's example from earlier on of the assault that took place in the correctional facility and the officer's reaction initially, and right, but what was actually going on in that moment. But the categories that we place people in limit thinking beyond that. I'm deeply cynical about a lot of things in both the law and in life. But what I'm not as cynical about, strangely, is that through some of this work done correctly, not only can we like confront and undo a lot of the harm that the criminal legal system has done in people's lives, but we can actually foster some sort of healing. But it has to be done correctly. And where we started this discussion with Teresa's experience of having to just go through every single thing in order to get that part in, which, you know, as Jillian explained, is just not the mechanism that we need. It's not the right fit for this. This is about making a law that might accomplish all of these things. So I think it's helpful to come back to just how we think about things, and can we think about things differently, as Jenny just said.
Joette, did you have any other questions from the chat, or we're almost to 2 o'clock? Oh, Joette, you're muted.
No, I just see that there are many questions in the chat room, so I'm just looking at you and Cynthia as to whether or not you can.
Can we take one more at least?
Absolutely.
Great. Cindy, do you have one from the chat?
Yeah, so we had one that asked, is the argument being made that a burden of proof of clear and convincing evidence is too high, with the understanding that oftentimes the evidence is the testimony of the victim requesting vacatur? So I don't know who wants to take that. I think Kate, maybe it looks like you want to take that. If you could speak a bit about that.
I'm really still thinking about the point made earlier that maybe a burden of proof is just not even required or appropriate here. I kind of dare any of us that are lawyers or like, to say what the difference is between preponderance and clear and convincing and how you would actually apply that in a petition to vacate a conviction,
Yeah.
like what that would look like. What you've heard from Rich, from Jenny, from all of us is that there's a lot of work and thought that goes into this, but it's not quantified in a formula or a number. Or and so I think this I'm having a change of thinking as we're doing this today, which is that I think this might be a distraction. I don't actually think this is really essential to the work that needs to happen. But yes, preponderance is a lower standard, we all know that, than clear and convincing. And so to the extent that we want to open the door for relief, if there is to be a standard, we just need to take into account the practical reality of what we're asking people to provide. But I don't know that the standard itself is a guard against abuse or misuse or in any way really impacts that.
I'll just weigh in briefly. I mean, it's the point that I was raising very early on. I mean, we ask judges to do so much, and we do it without tethering them to a particular burden of proof, as in sentencing. So, but using that by way of example. And I think we have an opportunity to really think about what makes sense. We use this when a lawyer's making a claim that a statute is unconstitutional. We've adopted this language that says you've got to prove it's unconstitutional beyond a reasonable doubt. That makes no sense. I mean, it makes no sense if you really stand back and think about what does it mean for a lawyer to prove a statute is unconstitutional beyond a reasonable doubt. But it's language that we grafted, 50 years ago, whatever, and it's come into question since. But I think rather than do something and then have to spend the next 50 years thinking about why did we do that? Did it really make sense? I think we have an opportunity here, and I would invite you, Jillian, with your colleagues to, frankly, my view would be to not include one. And I don't think it's necessary. And I think, again, I begin where I end where I began, and that is we demand a lot of our judges and a lot more than this. And I think they're certainly capable of doing it without demanding without saddling them with a particular burden of proof, and then having that become an issue.
And unless I'm reading it wrong, I mean, the one that I did was by agreement. I filed the motion and said, I agree to this, judge. I brought the motion to him and said, sign it. And it seems like that's what Jenny's doing also. So it's almost like, you don't have to prove it in court. You have to just show the prosecutor that, hey, this is why there's no confidence in the conviction, and, do the right thing. And I think people are going to be pleasantly surprised that, prosecutors are going to do that. I mean, that's our part of the system. That's what we should do.
And Chief Justice Colangelo, just to clarify, if everybody hasn't seen it in the chat, that was the single case since the passage of vacature in Connecticut that has used the statute in order to vacate a conviction. We've had it used exactly once. And in that case, it was a petition on the papers. The survivor did not have to go before the court. Is that right? And present testimony and be cross-examined?
Didn't go before the court. I actually didn't even talk to. I just got the paperwork, looked at the affidavit, and it's one of those, when you see it, I mean, handling cases for 27 years, you kind of, yeah, I get it. I mean, Teresa comes forward and says, hey, this happened. Victims of these crimes usually don't do that. It's very difficult for them to do that. And for somebody to kind of come forward and do that, that struck a chord, and you kind of move forward with that.
Sheila, we could go on all afternoon, but our time is up. But I would suggest one more question.
Great, and this one's going to be a hard one. Do we have any studies on what the effects of vacature are for victims? I feel like Teresa may have alluded a little bit to it, but I'm wondering, even if we don't have the statistics, can we just end on a highlight of what does this actually mean in the lives of victims if they have convictions that have been vacated? Anyone? Jenny, do you want?
Sure.
Go ahead, Jenny. Yeah, please.
Yeah, I mean, I know for the writer of the letter to the correction officer, she is living in a good home with her children, and she has a good job right now. And that was everything for her, having her criminal record expunged. I can say on the flip side, this is kind of a bad thing that's happening in Florida, but the Florida Department of Law Enforcement has not complied with multiple court orders for multiple survivors in actually expunging their record. So when somebody's record is run, they are the keeper. So they haven't complied with orders. And so I had a victim on a case who I expunged her petition. This was the one who I did while the case was pending. And she is an incredible woman. I could talk about her for a whole hour, but she was under the belief from 2 years ago that her record had been expunged. She made vacation plans for her and her children at an Airbnb before Christmas. And she had the reservation canceled because of her criminal record, because the Florida Department of Law Enforcement had not complied with that order. And she sent an email to myself and her pro bono attorney, just full of anger towards us, couldn't believe, because she's been doing amazingly well. She's had no interaction with anybody who would run her record during that time. And then this happened. So I think on the flip side, it just shows how powerful this can be. And also, if an agency doesn't comply, like, what a horrible thing for this woman who has come so far to experience with her children, to have their vacation canceled, so that's just a small example. But I think it's everything for people, as Teresa has said, and as I think all of our points have illustrated. That should be in 2 weeks, by the way. That's what they're saying, or one more week, hopefully.
So I just want to leave this an understanding of what it's been like for the past year. And, I own a car and I own a home, and, I'm employable. I have friends. I go bowling. I have, 3 rescue dogs, a cat, and 9 fish. Today I have the capacity to feel free, and I've never had that. And I can send my resume out with confidence, because not only has my, once I got that pardon, doors open that I never had a chance to. And what I had done, I'm free from today. That bond between me and, they used to call me Terry. And, I can safely say we have buried Terry. And Teresa is an amazing woman.
Thank you. We applaud you. And thank you for joining us, Teresa.
I want you guys to hear the positive. What happens when someone gets that vacatur, when that does come into play.
And I think the one thing that if it's not obvious is how exceptional you are when in hearing your story, just the incredible obstacles that kept presenting themselves in your way and how you just persevered. And I really feel like we are seeing someone who really has victims hidden and standing behind her who have not been able to get there. And we're hoping that this will represent some.
The other day I had an opportunity, a survivor, she went to a 30-day program, and she was afraid to go home because there was paraphernalia and alcohol and drugs. And she called me, and we went and cleaned the place out, and I was so honored that she could call on me, that I am more than who I used to be.
Well, thank you. And I don't know if anyone else has other comments, but I am incredibly grateful to you all. You come from such a broad swath of disciplines and areas of interest, and yet I think we've all managed to come together and really have an incredibly eye-opening discussion. I think, to steal the words of some of the panelists, we have to do better. As Representative Gilchrist said, we need to fix this. And I too have had a lot to think about, because we have discussed what criminal convictions should be eligible. And I think we're all feeling very strongly about moving beyond just prostitution. And I'm now thinking more that, should we limit it? Should we exclude A and B felonies? Should trafficking be included? And also whether it makes sense to leave the statute silent on the burden of standard of proof or whether that's something that should be imported. But thank you so much for your questions. I think Cindy mentioned that if you have any others, please reach out to us. And I just wanted to say thank you so much to the panelists. And we're moving forward. I said to the panelists and hopefully to the audience as well, that this is the step in terms of legislation. This is how our democracy works in Connecticut. Everyone can testify, can submit evidence. So if you're interested in doing that, let us know. But if you just want to do it informally, please reach out to your legislators on this issue. We're happy to help you, or you can just send something yourself. And Cindy is actually my student putting together a change.org petition. So we'll send that around. But do be in touch if you're interested in this issue. And once again, from the bottom of my heart, thank you to an amazing panel of people.
Thank you, Sheila. Thank you
Thank
so
you.
much for doing this. Bye, everyone. Great to be with you all. It was an honor and a privilege. Thank you so much.
Thank you.